Okay, Anya, did you mail your synopsis?
Yes, sir, I did. I mailed it to you on 11th June.
No, no. What
Wait,
I'm
that's today.
the synopsis contain dates of event. Can you please tell me, Anya? Am I audible?
Yes, sir, you're audible.
I'm asking along with the synopsis. There's a requirement of list of dates. Did you contain them?
Yes, sir, I did. Have you not received it yet?
No, not yet.
But I was there in yesterday's class too, and you said the same thing, and then I sent it to you again.
Resend now. Uh, Mail is not having your synopsis.
Okay, sir. Can I send it to you like via some other platform instead of emailing it to you?
Okay, do WhatsApp.
Okay, sir.
Mahati.
Yes, sir. Can you hear me?
Yes, I do. And I'm not
Yes, sir.
your any synopsis in the mail.
Sir, I sent it to you day before yesterday.
No, no. I'm not talking about the list of date which needs to
Oh,
be
sir, I had not attended yesterday's session. I just saw your message at like 9:55 about that.
and didn't go through a video recording.
No, sir, I was actually traveling. I will see that today, like tonight.
Mhm. Hanshika, am I audible, Hanshika?
Yes, sir, you are audible. Sir, I'm still working on my draft as you have mentioned few recommendations, so I was going through that only. I have not completed the correction you have told me.
Okay, the synopsis must contain list of dates event wise. Okay,
Yes,
and
sir, I'm working on that too.
okay, Tirthankara.
Sir, I'm sending it.
Okay, Harshita.
So the previous synopsis was approved by you, and the list of dates and the things you mentioned in the yesterday's classes, I'm still working on that. I can send it to you by today.
Arnav.
Yes, sir. I was just doing the changes that you like asked me to do in the last class. I've not completed it yet.
Okay. So yet I have received through mail Disha and Kush. So I'll start with the Kush. I'm going to share my screen where I'm demonstrating or presenting Kush document that is there in yes. Is it visible?
Yes, sir.
Okay, this is the first page. No issue. We start with here. Synopsis and thereafter synopsis contain issues challenging to section 14A and then challenge to secularism and fraternity. challenge to pro- provision added by Section 6. If that is so, then did you mention above?
Yes, in the
Sec-
second point.
okay. Challenge to provision added by Section 6 of Citizenship Amendment Act to Clause D of Third Schedule of Validity of Proviso inserted in Section 2. Can you explain what it is all about?
So, like in third schedule, it is the procedure through which these six communities will be given the citizenship prior in Citizenship Act 1955, which was inserted by 1987. The procedure which was to be used to give these six communities the citizenship, but this time they amended that schedule and made it not less than 5 years instead of 11 years in this third schedule also. So that's why I mentioned that. And in section 2, they inserted a proviso to say that they will not be termed as illegal immigrants, and that's why that section also.
Okay. 5th, 15th August 1947. There was debate in 1950s and the criteria of citizenship criteria. This criteria of citizenship. Criteria was decided as the basis of birth, etc., and the religious criteria was rejected. The idea was based on the principle of secular state. That is, the constitution made India a secular country, and we cannot neglect secularism in the citizenship criteria, which is to say that we have to follow the principles of secularism in true sense. 26 January 1950, Indian Constitution was enacted. Article 5 to F was inserted. Aryan Kapoor. Okay, then 1987. Person was born in India or on after January 26, 1950, but before July 1st, 1987, is a citizen of India by birth irrespective of nationality of his parents. Okay. Citizenship Rule 23 were introduced, making the condition for citizenship registration more stringent. These are the notifications state. Union government issued an order under Section 16 of 1955 Act granted district collectors in 5 states with high migrant populations the power to grant citizenship to groups identified in the 2019 amendment. Okay. Kush, this was completely fine. And next is Disha.
Sir, I had sent you a mail like half an hour back with some corrections. So can you like just please open that one? Like I had sent you two emails. So in reply, I had sent you another one.
Okay. Okay, let me share screen. Visible?
Yes, sir.
14A, 18.3, and then notifications. So first is validity of section 14A, second is 18 clause 3. You didn't mention number. Provide numbers to all the challenging points, challenging headings.
Yes.
And this would be the third, then fourth, fifth, and the sixth. 1950. The topic of citizenship was of the most debated upon subject in the Constitutional Assembly. Even Dr. B.R. Ambedkar had acknowledged that a high level of difficulty was faced by the constitution makers when it came to reaching a consensus as to who shall be entitled to Indian citizenship and who shall be left out. Okay, 1955, 1987. Okay, please explain just solely principle.
Like, should I explain it right now?
Yes. Tell me,
So,
what is the
uh,
meaning just solely?
so basically, Josoli principle states that a person, if they are born in that land, then they get the citizenship of that country. Like it's, and then there's just sanguini, which is basically means that you get the citizenship of your parents, like the country that their parents belong to.
Good.
So countries like USA, they follow the Jersey principle.
Okay. And also you had to mention 2019 bill that was passed, Citizenship Amendment Act 2019. That
Yes, sir.
was the
I'm so sorry. I
inclusion
forgot
of the
about
list
that.
of
I'll add.
bills. Yes,
Yeah, I'm so sorry.
it's okay, but do mention.
Yeah.
Okay, overall everything is fine there. Next, Tirthankara.
Sir, did you call out my name?
Who's that?
Anna.
Anya. Did you message me or did you WhatsApp me?
What, sir?
Did you send your document through WhatsApp?
No, I emailed it to you. I wanted to see if you receive it, but have you received
Actually,
it?
no email is received from your end. That's why I had asked you to send me through different mode. That is, use WhatsApp.
Okay, I'll send it to you right now.
Yes. So, Thir Thankara Reddy. I'm just sharing my screen.
Yes, sir.
Okay. Is this your
Yes,
document?
sir. Sir, I talked about the notifications in between the numbers from 1 to 12, sir.
Okay, numbering issue is there. Also, instead of using points, use Roman numbering.
Okay, sir.
And these are the paragraph numbering. So try making structuring in such a way that the paragraph should be tracked by their heading or the challenging points.
I will edit it, sir.
Add heading as list of dates, or even you can events, add events, anything.
Yes,
So
sir.
you had started with 1920. Passport Act was enacted. So what was related with this Passport Act? You had to explain it. You have to correlate with the citizenship. Although everyone knows that the passport is the identity of the citizenship, but also you have to explain here and correlate with the Citizenship Amendment Act, or at least with the citizenship,
Okay, sir.
and also explain Foreigners Act. Why is it necessary to mention here, and whether it is related to citizenship. And then it is 1950.
Yes, sir. I'll change them.
Yeah. Then 1955, Constitution of India came into force. 1955 was enacted. Then 2015. You didn't mention all along the route
Yes,
of
sir.
the
I
evaluation.
borrowed information from some articles, so it's kind of messy, sir. I'll edit them.
Do mention 1987, 2004, 2004, then 2015, and then as per the notifications date, do mention, yeah.
Okay, sir.
And then 2020, in spite of impassioned protest by the petitioner and the lakhs of other similarly minded citizens and organizations across the length and breadth, the government has unequivocally stated. See, remember one thing: the purpose of drafting a writ. Basically, we are drafting a writ. Okay, so whenever we
Yes, sir.
draft a writ, at least we have to go on such date where we could say to the honorable court that after going through these events, the present petition is filed on on so and so date. Okay, so
Yes, sir.
suppose it is 2020, 2024. So in 2020, you had mentioned all these things, that the petition is filed against the Citizenship Act. So that is filed in 2019 actually. Okay, most of the petitions are filed in 2019, and thereafter most of the petitions are filed in 2022, 2023, then 2024. Before March, most of the petitions are filed. So what we can write is, if we are filing any petition in 2014, 20, that is 2024, then we can mention that the present petition is being filed in 2024, and before that all these kinds of event occurred. Okay,
Yes, sir.
we the purpose of purpose of mentioning all the event is to let the court know that the evaluation of issue arises since 1920, and various uh, amendments took place, and thereafter the bill was passed, and now just because of those issues we are filing present petitions. Okay,
Yes, sir.
in 2024. That's how you can mention.
I'll share that.
Yeah, we are not here to inform the judge. Even if we are if we are informing all these stuff, these are baseless, because we are not there to tell about other petitions. We are here to mention about our petition. Why are we filing this petition? Just because of this was passed, the issue was directed, and further these are the evaluation of the amendments. That's how. Okay,
Yes, sir.
rest of the things are fine. And next, nobody haven't received from Anya, and rest of the other students are required to do submit maybe tomorrow. And now I'm going to start with the original petition. I have already shared a format of writ. A format of writ is about this petition only. So I will discuss this format. Is it visible?
Yes, sir.
Yes, sir.
So as earlier we told you that this synopsis and list of dates has been enclosed. So that means whatever we have earlier written, those are synopsis and list of date. Those documents will be enclosed with this original petition. Understood? So A part is covered now. We'll move to the B part. B part is about writing this petition. So in the Supreme Court of India, original jurisdiction, civil writ petition number, we don't need to provide number. This is done by the registry, but we can write off 2000 or 2024, because we are filing in 2024. Okay, and then in the matter of, so the petitioner would be the person who is filing this petition. Any of you, like Kush is the petitioner, and versus. So the matter arises with the government, and government ministry is the sole responsible. Even the legislative body is the sole responsible, and those are headed by the Union of India. So we can mention the respondent name as the Union of India. Okay, individual name versus Union of India. Then petition and under Article 32 of the Constitution of India for the issuance of a writ in the nature of, whatever the nature would be, we can define it accordingly. Either habeas corpus or quo warranto or certiorari. These kinds of notifications are there. I mean, writs are there. So before that, you must be having prior knowledge about writ. So how many of you having such knowledge? Tell me. Any of you having knowledge about writ? No one? Haven't you gone through ever Article 32? Am I audible?
Yes, sir, you are audible.
So haven't you gone through any of the writ? Even in 12th standard, it is mentioned about the writ. Am I correct?
Yeah, so in like first year, we had like a few cases about habeas corpus and writ of mandamus.
Okay. And any other person? Nobody? Okay, so let me tell you. Basically, under Article 32, there are 5 to 6 writs. Writs are generally, that is the category of directing, getting the direction from superior court for the inferior authority or anybody or the inferior court. Basically, we are seeking direction from the court for the government body, and even along with the judiciary too. For the lower court, we even seek direction from the higher court. So those are directed through this writ. So among the writ, there is one habeas corpus, second is certiorari, prohibition, mandamus, and then quo warranto. These writs are there. We need to understand. We have even these kind of writs are known as a general understanding, general knowledge. Wherever you take any exams, any competitive exam, writ is asked most of the places, in most of the exams. Article 32 contained types of writ, and writs are always asked. Okay, so the thing is, this Article 32 mostly empowers Parliament, okay, to issue any kind of directions or any form of writ before the Supreme Court. This is one kind of power, even for the individual as well as for the government body. Everyone file writ before Supreme Court. A layman, if their fundamental right is abrogated, infringed, then the simple way is to go through the writ. Writ is filed under Article 32. So we seek generally direction from the court. Okay. So you can note down. In short, I'm just going to explain one by one. Please note down. Habeas corpus is one of the writ under Article 32, and this writ is to enforce or to protect the fundamental right to liberty. Okay, any individual who is detained unlawfully by the government, or by the police officer, or by the government authority, then we can file a writ petition containing habeas corpus in the heading of the writ, and seek direction, seek issue to release that particular person because the person is unlawfully detained. Understood? But the condition for this writ is, whenever you find the person is arrested, always inspect the person is arrested lawfully or unlawfully. Because see what happens when any person is caught by the police officer or detained by the police officer, the person is to be produced within 24 hours before this court. But in case that person is not produced before the court, and detained in the custody at least 24, or that is after 36 hours or 48 hours, it means it's going beyond 24 hours. That means the person is unlawfully detained. And in such a case, prior to seeking Supreme Court or High Court direction, we had to visit the uh, uh, particular uh, police station or the center, and we can ask them to release that particular person. If you find that is not effective, then only you can seek superior authority, or that is superior court help. So for the enforcement of fundamental right, everyone has to any, anyone everyone has a right to move in the territory of India freely. So any person is detained unlawfully, then their right is infringed, and then we can seek direction from the court. For that, we can put their mandamus. Like if we are filing petition, we can write petition under Article 32 of the Constitution of India for issuance of a writ in the nature of mandamus under Article 32 of the Constitution of India. Any issue?
No, sir.
So
Similarly, there is another type of writ, certiorari, and it is issued to a lower court, means either high court or to the district court, session court, that means the lower court. Even if if you're filing before high court, then the high court can issue uh, direction to the lower court. And if you're filing for the against the high court before the supreme court, then the supreme court will issue direction for the high court, that means lower court. So any if you think any decision is passed by the lower court, and that is let me so any decision is filed by the any decision is passed by the lower court, and if you think that decision is not satisfactory and there is a bias in the decision, or the decision is not favorable, or there is a glitches of the law, or the law is not followed, the procedure is not followed, so ultimately if you have any objection by the act of the lower court, then you can seek a writ containing certiorari under Article 32. Okay, the writ in the nature of certiorari. So that is what I was telling you. And secondly, the third writ is prohibition. Prohibition is a writ issued to a higher court. Okay, sorry, it is a writ filed if you are filing before the high court or supreme court. The writ is issued filed on behalf of the petitioner before the supreme court or high court, and that prohibition writ is directed by high court or supreme court to a lower court, or to a ministry or the government body, if they are doing some kind of act, or if they are passing any rule or any legislation, or any kind of the order, if they are executing, then the prohibition writ could be issued against them through the court. Okay, so suppose if something is going to be suppose there has to be one kind of judgment is passed against the petitioner or respondent, so that person thinks that there should be a stay, or there should be some kind of prohibition in execution of something, then the prohibition writ could be filed. So you can write in such a way that prohibition is a writ issued by a higher court to a lower court to enforce inactivity in the jurisdiction. Okay, so something that is passed by, or something that is directed by the lower court, then only we have option to go through this kind of nature of writ. Then we have mandamus. I will ask one by one, so please understand these kinds of writ carefully. Mandamus, the writ is issued to a subordinate court or an officer or the government body or in the corporation or to any other institution. Why? To command, to ask them to perform such duties. If they are not performing their duty, then we can ask the court through this mandamus writ. For example, any government authority is not releasing your debt or anything that is their duty to perform as a government employee, but they are not acting according to their policy and rules, and that is how your fundamental right is violated, because you have right to seek such thing, you have right to get such something released through the government authority. But in your case, government authority is lazy, not listening to you, and you have approached multiple times, but you find it is not effective. Then you take the help of the court and file a writ in the nature of mandamus. So the writ of mandamus can be used to order the completion of a task. Okay, that is for the mandamus. And lastly, we are talking about quo warranto. So the quo warranto is issued against a person who claims, or any public servant who claims that uh, they are inquiring something or they are claiming something individual basis, then we can file quo warranto. It means we are sending a warrant of something to inspect, and for that we are seeking help of the court. Okay, so that is how these kinds of nature of writ can be filed before the Supreme Court. Yes, Kush.
Can you please explain quo warranto again?
See, the quo warranto is issued against a person. Okay, so we have to first of all try to understand the distinction between quo warranto, prohibitio, and mandamus. We have multiple the slight differences between the nature of writ. So as you have understood previous claims of the nature of writ, similarly quo warranto is issued against a person, whether who is a public officer or a servant. So we can file a writ before the Supreme Court and ask the court to inquiry or to inspect about their claim, or their whatever they are conducting. We can ask the court to inspect or inquiry in such matter. So the court do one thing. Court directs quo warranto. It means the court has sent a warrant against a person. Understood?
Yes, sir.
So there is only slight difference. We can understand their nature of writ, and there are more example we can take on just to understand the quo warranto. And along with that, if we talk about any other writ, even prohibition is there just to we are seeking court to stop them from doing something, so we use prohibition. Okay, for example, if we talk about police officer is there, they are holding any position and they are claiming to be the powerful person in their own position. And even if they don't have even if they are not bearing such power, and but just because they are holding such position and they are doing something extrajudicial work, or they are doing something which is not in their power, so that means the public, that is the public officer, and they are claiming something which is not in their power. So then we can file a writ containing quo warranto. So the court will send a direction in the form of warrant and ask. It is just like we can see suo moto. Understood?
Yes.
Disha.
So in the case of CAA, will we be filing a writ under mandamus then?
Yes. So in the see, what we can do is there are a lot of things which we can use. If you talk about mandamus, so the mandamus. Have you understood the mandamus?
Yes, sir.
Yeah. Okay. Let me ask one by one first of all. Then let me inquiry how many of you are favoring mandamus to be included for the PIL in case of CA. Theer Thankar Reddy, can you tell me what will be the what exact nature of writ will be used here?
Sorry, sir, I don't know that.
Have you understood all those five writ?
Not really, sir.
What is the issue there?
I'm not sure, sir, but I couldn't get it.
You didn't get it. Even you didn't ask again.
Sir, I was thinking to go through the video tomorrow.
Then what is the benefit of having live class?
I mean, I have doubts, sir, but if I hear again, I think I could clear them.
Mm-hmm. Okay. And Mahati,
Yeah, so I think I'm confused between mandamus and prohibition, because I think mandamus, we can say that they're like neglecting their duty, but also we can say in prohibition that they're exceeding their jurisdiction by like unfairly excluding.
that's why I had mentioned the slight differences we have to understand.
Yeah, I know that they're not the same thing, but I'm not sure which one applies here.
Okay, let me be clear. Uh, I'm starting again the types of writs. So the habeas corpus provides protection against unlawful detention by the state or private authority. That is the first thing where I had discussed about the detention unlawfully. Okay. Second is habeas corpus is clear to all of you. If
Yes,
any
sir.
Yes, sir.
if any person is uh, detained under the detention unlawfully, then we can file habeas corpus. And in regard to mandamus, mandamus is an order given by the court to various executive authorities. Okay, so we are talking about the various kinds of authorities. If they are not performing their duty or their the work, or if their work is not satisfied. Suppose there is a tribunal, or there is a lower court, or there is a public forum, and if they are not performing their duty lawfully by the process or by the policies, and because of their activity, people's fundamental right is violated. Okay, so in such a sense, we can file a mandamus, and there are the two or three kinds of the major flow here. What we can say is mandamus is filed against any private person or individual or any private organization. In similar way, mandamus is filed to the against the lower court or the lower authority. Okay, even it is filed against the, even for the president of India. If you think the president of India is doing something violating the people's right, then it can also be filed against the president or the governor of state. So ultimately, even in habeas corpus, there is a violation of fundamental right. Even in mandamus, there is a violation of fundamental right, and all those violation arises if under fundamental rights, then we have writ under Article 32. But the slight difference is the writ which we had talked is about habeas corpus for unlawful detention, mandamus from higher authority to lower authority, from the court to the lower authority or the government authority, or to the private individual, or to the what I was talking about is uh, government authority, government corporation, government organization. They only we can file these kind of writ. But for the private individual or the private authority, if they violates anything that comes under the civil or criminal law, if they are if they do something against the law, if they do something which is contrary to the fundamental right, we cannot say that our fundamental right is violated. Suppose if you go in the street and your neighbor start preventing you from crossing the street, it means your neighbor is trying to quarrel with you and preventing you from the street. So that means that is not a matter of fundamental right. Even though you have fundamental right, but that is not a matter of fundamental right. For that, you cannot challenge government. You cannot uh, file a case against the government that you have certain right to move freely throughout the India, but your neighbor is preventing you from going anywhere. Understood? So you can not file any petition against the individual. Individual can file against the government. Is it clear?
Yes,
Please.
sir.
Yes. Mahati, is it clear?
Yes, sir. I think I got it. I'm still little confused.
Again confused.
Yeah, because if it's lower authority, then it'll be the last one, right? Of Sertoria. I don't know
I
if
will
I'm
come
spelling
to
it.
that. I will come to that.
Okay.
Okay. But Tirthankara,
Yes, sir, I got both of them.
yeah. See, the mandamus uh, can be issued against a tribunal, corporation, public body, or lower court in certain situation. Okay. But if we talk about certiorari, certiorari is an order by a higher court to a lower court or tribunal or any forum in the matter of cases, transfer of matter. Suppose uh, there's a case under the Uttar Pradesh jurisdiction, and the case is under trial. and you are staying in Delhi. Just because of the natural reason you are unable to visit UP, Uttar Pradesh again and again. So you seek court and ask court to direct the lower court of Uttar Pradesh, of any district court, and ask the court to transfer the matter and entertain in Delhi. So there we are using certiorari. It is not just about transfer of matter, but also in most of the matters, if we have to direct to the lower court or tribunal, we use certiorari. Suppose even in case of any order is to be quashed, if suppose any order, suppose there is a Salman Khan matter, lower court punished and sentenced him to jail and fine, but high court has stayed, and even I heard then the whatever the imposition was there on Salman Khan, that was removed by the higher court. So that means there's a type of nature of certiorari. Certiorari is issued to the lower court to stop them from passing order or to quash their orders. So particularly certiorari is filed for the lower courts or tribunal. Is it clear?
So, sir, how is it different from prohibition, which also stops jurisdiction?
So see, the in case of prohibition, it is all about jurisdiction. Suppose any matter is doesn't fall under Delhi jurisdiction, but still you are trying to file under Delhi. Suppose the matter is committed in Uttar Pradesh and you are filing in Delhi, and suppose the court is entertaining such matter, and the person who is a aggrieved party residing in Uttar Pradesh, the person can directly seek the higher court and ask for the prohibition. Okay, so the
Okay.
higher court will pass order and remind them their jurisdiction, and it will be asked by the higher court to the lower court not to entertain this matter because this matter doesn't fall under your jurisdiction. There only we can file even prohibition, and for quashing matter we can go for the certiorari.
Okay, so understood.
Only the slight differences are there. We have to understand by the various examples one by one. I hope,
Okay.
yes, I hope you understood. And from your own perspective, go through all these kinds of nature of read and try to understand with the various examples. Even sometimes teacher try to teach you with their own examples. Even I know whatever I have learned, and sometimes I get confused too. So whatever example I take may not be the sufficient for you to understand its differences. So it is far better to check it out yourself and find out how you could understand its differences. Okay.
Okay, so
Yeah.
thank you.
Yeah, and we were talking about, that is, yes. So here, what we can do is, see, we are leaving upon the court to decide what kind of order they are passing. So for that we can just file petition under article 32, We are not deciding them to prohibit, prohibition or qua warranto or certiorari. We are not deciding them to do. We are challenging the laws. So here, if we are challenging any law, it is up to the court to decide what kind of nature of writ could be, I mean, against, on behalf of which kind of writ the court can issue direction. So it is up to the court to decide what nature of writ could be used there. So whenever we file PIL specifically, we mention petition under Article 32. If we are sure that there is a writ of mandamus, then we can emphasize about the mandamus. And since large number of people are affected by by such kind of issue, and you think that there is a need of mandamus through which judge can or the court can issue direction, then you certainly provide mandamus or certiorari or quo warranto. But if you are not sure that a matter is, matter is debatable, and then matter is in such a nature that you even don't know what will happen, then let the court decide. Understood?
Yes.
Yes, Kush.
Sir, if let's say I write here mandamus and that is not appropriate for, like, according to the court's point of view, it should be prohibition, then will the court issue prohibition or will reject the petition?
See, in most of the matter, what happens when you file PIL? If court thinks that there is a gravity in your challenge, then in most of the cases, court issue direction. So when the direction is passed, it means court directs the lower authority, and you even don't know whether you are you should file mandamus, certiorari. So it is, even court doesn't care about these things. Court understand that the large number of people are affected, and that's how you are living upon the court. So in such a case, court decide that what kind of direction is to be passed, but you are not asked to file again a writ containing mandamus or certiorari. Okay.
Yes, sir. Thank you.
Okay, and so coming to the next line. Yes, I was there. Honorable court. So we are filing any petition, any writ in the name of Supreme Court judge, that is the Chief Justice of India, and his companion judges. So we mention like this. And then coming to the fact of case. All of you are aware of the fact of cases? Tell me, any of you? Disha?
So I think we'll here write about the fact that certain minorities have not been mentioned in the
Yes,
Citizenship
yes,
Act.
yes, yes, that's
And
the fact.
again, we can also mention how the cutoff date is not logical in the
Yeah.
sense.
So
And why
whatever, yes,
yeah, yeah.
yes. So whatever you have mentioned in synopsis, those paragraph or those section article will be explained here. Okay, fact of the cases will be explained. So how we can explain? Before that, when we start writing, we have to start with to the honorable Chief Justice of India and his companion judges of Supreme Court of India. And then we can mention about we can write most respectfully, and then we can talk about the petitioners, like we had started with the petitioner in synopsis, all about writing that the petitioner is a public interest litigant and is filing this present writ petition against the respondent, seeking relief of declaration that the Citizenship Act 2019. And then you can mention that the article or the section of CA is a violative of Article 5, 6, 11, 14, 15, 16, 19, 21, 25. And then you can mention that the whatever the challenges are, the validity of section 14A of Citizenship Act, validity of section 18(3) of Citizenship Act, and then the notifications, challenging the notifications. And then you have to provide next heading called credentials of the petitioner. So we have to explain the credentials of the petitioner, that the petitioner is a public interest litigant, petitioner is a public activist, and so on, as you have mentioned in the synopsis. Then the most important fact is facts. So, as this is the example fact of the case, we can write facts leading to the present petition. What are those facts which are leading to this present petition? You have to explain one by one. So, here you can start writing from the list of dates. So the list of date is contained only summary. The events are in the form of summary, but here you have to explain like you are writing a book and mentioning every events within 4 to 5 pages. So as told you, in 1950 there was a discussion in the Constituent Assembly. So for the Constituent Assembly you can explain and mention everything whatever is discussed in the assembly, and that is regarded to the citizenship. As I told you that the Constituent Assembly, uh, first part of the debate talks about the Indian citizenship, and the draft was prepared in such a way to qualify the Indian citizens, but there was varied view. Some of them were against the religious point of view, some of them were the secular point of view. So everything, every part of debate could be explained here, and whatever quotation you want to quote you can quote here, and whatever the summary of the events you can explain here one by one. Even you can write pre-independence about the citizenship, then after independence citizenship in India, and then you can explain about the post 2004, what had happened. Illegal migrant was removed, legal migrant was added. So everything you can explain one by one. And remember that the synopsis is considered as the summary. As you, if you have written uh, synopsis within 6 to 10 pages, then the original application would be around 20 to 30 pages or 30 to 40 pages minimum. Explain as much as you can, and whatever has uh, passed, whatever the laws were passed by the parliament, for that, what was the culminative effect against the particular religion? You can write about all those things, and you can emphasize what exactly is the issue. If the government is taking defense about their persecution, then you can mention that the persecution is taking place for every kind of defense, but the persecution word is not defined. So you can emphasize on the specific word too, because the government has taken the defense of persecution. Government has said that the minorities are persecuted in their own country, but the Word persecution is defined nowhere. And similarly, you can write some more lines, and then once you complete this, we'll talk about grounds. Okay, we have to talk about grounds as well. Question of law can be mentioned uh, in a form of question. Either you put three or four question, then you can write question number one, question of law, and then question number one, question number two, question number three, like that you can mention, and thereafter you can mention grounds. So we will discuss about the grounds tomorrow, but I want you to start writing about the facts. I didn't get much time to explain the facts, otherwise I could have explained everything. But whatever I have explained, at least you would be having a prior knowledge as you have written synopsis. Understood?
Yes, sir.
Any other question if you have, please ask. Tomorrow I want all of you to provide me this kind of uh, format of writ petition containing petitioner name, respondent name will be Union of India, petitioner name will be yours, and then petition under Article 32 of Constitution of India for issuance of writ, and then of Constitution of India. That's all. And then to Honorable Supreme Court judges, the exact line you can quote, and then you can write most respectfully. Explain about the present petitioner is a public interest litigant and is filing writ petition, filing PIL against CAA 2019, and also as else following uh, sections and notifications. And then you can write credentials about the petitioner, and then you can write facts leading to this present petition, and then if you think you can make out some question of law, then you can, and I will discuss regarding the grounds tomorrow. So first and second point to above, prepare in a format of writ. Understood? Tomorrow we'll talk about grounds, and then after the ground, the next is after the ground, nothing is there. There is a prayer will be covered tomorrow, and that's how petition will be completed. And thereafter tomorrow we will talk about other miscellaneous filing. Disha, yes.
So we have to submit the facts of the cases tomorrow.
Yes.
Can we get more time since you said that they go like for 20, 30 pages? It will be a little difficult to like complete them by tomorrow.
Okay, do one thing. I give you tomorrow. Uh, what is today? Let me check the calendar.
It's 11th today.
Yeah, is it Tuesday or Monday?
Tuesday.
Tuesday. So Tuesday, uh, Wednesday, Thursday. Thursday is fine for you to provide me the original petition.
Sure, sir. Thank you.
So day after tomorrow, prepare. Uh, I mean, provide me. Uh, that is the present application till 10 p.m. And tomorrow I will be discussing related to grounds, and then we will be holding class on Tuesday, Thursday. After tomorrow, Thursday will hold class, and Thursday I will check complete. That is petition containing everything, but for the grounds, since I will be discussing grounds tomorrow, and I'll give you 2 more days for that, because grounds is also much longer than you expect. So finally we'll end up the class, this drafting class, maybe on Sunday. Okay, so I expect everyone should complete these kind of documents till Saturday, so that Sunday will be the final day. Okay, I will not be entertaining thereafter. So try to complete all those documents: synopsis, list of dates, then the present application containing facts, and then the grounds will be explained tomorrow. Then will be given 2 more days for that. Clear?
Yes, sir.
Yes, sir.
Yes.
Okay, thank you so much. Good night.
Thank you, sir.
Thank you, sir.